So we're going to go through a few different topics today. It's just designed to give you guys an overview of some of the considerations, when you're setting up and developing a business. We're not going to go into a great level of detail. Of course, if you have questions during the session, just jot them down or you can throw them in the chat. And when we get to the end, just not to break things up too much, we can certainly address those. So the things we're going to cover today between myself, Eric, and Scott are going to be what's on your screen. So forms of business, the basics of incorporation, negotiation agreements, funding and financing, which is always important, and last but definitely not least, intellectual property. So we're kind of slated to run for about 20-25 minutes, and then we want to make sure that we leave enough time for all of you guys to ask your questions. That's what we're here for. So let's jump in. So let's just look at the initial forms of business that you want to consider when setting up a venture and enterprise. So I'm sure most of you guys have heard about some of these. Sole proprietorship is the one you're probably, most it's probably the simplest, but maybe the one that you're least familiar with. Sole proprietorship basically is you are your business. There's not a separate entity. You're not necessarily registering anything. It's basically, a lot of it used to be the mom and pop kind of convenience stores. Rural areas. Your pocket, your bank account is your business's bank account. So there's a whole bunch of potential risks that come with that, of course, which we'll talk about later. That can be alleviated through other corporate structures. The second one that we're going to talk about is partnership. So partnerships, again, you might have heard of this. They're basically formalizing an agreement or an arrangement between two people to cooperate with, the goal of having a profit and developing a profitable venture. The partnership agreement is what ring fences or kind of bookends, however you want to say it, the formal arrangement between the two people. Then we've got corporations, which is what we're going to focus on for today, as it's likely the most applicable and the most complex in a lot of ways, but also can be the most beneficial. So we're going to focus on that for today. And then lastly is joint ventures. We're not going to focus on that too much today. Joint ventures are very similar to partnerships, except that they typically are ring fenced around a particular project rather than an ongoing arrangement like a partnership. So, um, the key basics of incorporations are, the way we kind of put it is you want to do things right the first time. And that goes for a lot of things in business. But particularly when considering your corporate structure, that's really important. There are standard kits that you can purchase at the registry. You've probably seen them, on the rack when you're going to your driver's license or insurance or your registration. Those can be useful, but only if the person that's using them follows all of the strict instructions very carefully. Otherwise, oftentimes what we might see clients is that they don't, structure things effectively because they bought the forms and then they didn't submit something or missubmitting something, and they feel like everything's been set up and they've been running with this assumption that everything's set up. And the problem with that is that if you don't do things properly from the beginning at the outset, it can be very costly and complex to rewind the hands of time to correct some of these errors. So, while we encourage being cost effective about setting things up, something you want to be cognizant of. It's generally easier and a lot more cost effective to do things properly up front. But the other thing you have to consider with incorporating kind of the right way is what are the ongoing costs of incorporation. So typically, for a lawyer to incorporate a corporation for you might be $600 to $800 upfront fees, but you have to also look at that there are annual filing fees, tax returns, things that you have to do to maintain your corporation going forward. So those are also things that you have to consider in how you set things up front. The next topic is when to incorporate. So timing is key. There's not necessarily a hard and fast rule for this, particularly in your industry. But what you really want to do is consider the needs of your business. So corporations generally are there to limit liabilities. They're there to secure rights over assets or to hold your assets and to optimize tax planning. So the way you want to consider it is that there may not be initially a tax advantage to setting up a corporation in the immediate term when you're first getting off the ground and you're developing things. You don't really know what the value of your business, your proposition, your project might be, but it's something that you should consider. Don't wait and just look at the current issues, but you might want to look ahead to see where are you developing those assets to? Because if you go from assets that are or a project or a software that is not necessarily uh, um, super high value right in the beginning, by the time that you start developing it and releasing it, and now you're getting revenues and expenses and all of that, it might be too late to realize any tax advantages associated with it. So just be cognizant of looking ahead. Timing with incorporation is also important to raising funds. It's something we'll talk about in upcoming sections. So when you're doing things like hiring personnel or taking major risks or big development steps on projects, that's another time that you might want to consider incorporating and consider whether you want to ring fence and separate yourself from those risks, because in a corporation you are not the company, which kind of brings me to the next point of the proper use of a corporate structure. So you yourself are not your company, and it's really, really important to remember that all the things that your company develops, the relationships it has, the assets it has, the bank account it has, do not use those corporate assets, as you see on the screen, as your piggy bank. So those are things that have to be separate right from the beginning. Your accounting records, your tax records, all of those things have to be set up properly, which brings us back to how to organize everything properly in the outset, because otherwise you're muddling the line between those two corporate structures, and that's where a lot of the advantages might be eroded. So when you're signing documents, for example, sign all your documents on behalf of the corporation, right? You want to sign it off with Witty Development Corp signature, Steve Apple CEO, however you guys want to do it. But the point is that it's not you're not signing it on your own behalf. You're the representative of the corporation. So that's something you want to put forward to all the people that you do business with, employees, vendors, suppliers, customers, Kickstarter, whatever. Everything must be handled through the corporation in order for you to be able to take those advantages of reduced liabilities and potential tax benefits. Whenever you're, corresponding with people, include the corporation's name, trade name, all of that on documents and materials. You can see a little Nicol Law office in the bottom right corner. So those are all things that are important to consider. And next, we're going to jump into negotiation and formalizing agreements. So I'm going to pass that off to Eric. Thanks, guys.
Right, I've learned proper mask procedure from watching all those AHS guidelines, getting the mask off just as you get to the mic. Right. Just arrow keys. Perfect. Right. So the big thing that you've always got to figure out once you're actually doing something for money is how you're actually setting up your relationships. It's very easy when you're in the modding community to just say, "Oh, you're great at graphics," or "Oh, you do great sounds. Can you record some voice bits?" Once you start trying to sell something, people all of a sudden say, "Hey, can you pay me for what you did, or can I collect money for what I did?" Um, so I'll cover briefly the two main forms of hiring people. There are more than two, but the big two are employment and contractors. The employment is the straightforward one that most everyone has like familiarity with. The important thing there is that you're checking to see where the employee is and that you're meeting minimum standards. A lot of you are based in Alberta. That makes it very easy when you're hiring someone else in Alberta. You can look up the employment standards online. It's on alberta.com. But it gets a little trickier once you start having employees in other places. There are legal tests that will sort of determine whether someone is an employee in Alberta or whether they're in Quebec or somewhere else in the world. The short answer is that is complicated. The much easier way to do things like that is to have people be contractors. Now, you can have contractors on for all sorts of ways. Sometimes you have contractors on for a certain number of hours and they just do the work that you give them. Other times you ask them to complete a deliverable. So finish this model or create this track for the soundtrack. What's important though is that you decide up front how the work is going to be assigned, how the output that they produce is going to be given or returned to the company or whatever organization structure you have. But it's also important to sort of consider these things, because if you get them wrong, usually if you get them wrong as a contractor and the CRA says they're an employee or another tax authority, we're not going to into other tax authorities, we'll stick with CRA for today. But if the CRA comes knocking and says, "Hey, you've had this guy on for a year now, and you haven't paid any employment insurance and you haven't paid any Canada pension plan," we need that. And the big risk is a lot of times they try to collect the whole thing from the we'll call it quote unquote employer, who has paid their contractor. They've spent the money they were expecting to spend on this, and those bills can be big and they can be surprising. So when you're paying people for their work, make sure you know in what setup you've made that arrangement, and whether you're paying them, whether you're paying them as you can also hire them as their own corporation, or you can hire them as employees. The final bit, and this is a strange thing that I've weirdly had to look into, but an important element for both employees and for contractors is where they're working. So as I said, for employees, it's complicated. If you're in the country you're working in, you have to have a right to work. If you're not, if you're an employee elsewhere in the world, there's international laws about how they decide who's an employee. Sometimes most countries have unified how you do these things, but sometimes you have two countries claiming that you need to pay tax in both. But the other side of things is if you're hiring contractors, you need to know that where they're based is somewhere that you can trade with. For example, there's a big list of unauthorized countries and unauthorized people within those countries that you can't pay to do certain types of work. Great example, you cannot sell nuclear power plant equipment to Iran. So then you've got to ask, well, if I'm developing a game that has nuclear power plants, is that on side or not? So if you get into those areas where you're like, wait, is this a country I shouldn't be trading with? Is this a country that is on a sort of blacklist? And you can look them up. They're pretty easy to find. You got to make sure that your type of product is far away from the prohibited type of work. Go on to the next one there. The other kind of relationship that you have to work with is third parties. So these are people, you could call them vendors, suppliers, however you want to term them. The most common people that you'd be interacting with, probably like Steam, Epic Games, I guess the Apple Store, but I don't know if you get to negotiate with them. I think Epic's trying to figure that out right now. The big thing is the bigger the company, the more likely their terms are standard. So that means the date of payment might be flexible because they don't care when you pay them, as long as you pay them their share. But they might require that their agreement is actually in the U.S. or in China or wherever them as a publisher, them as a sales front are based. Other examples of things you can negotiate: free trials. Sometimes you can adjust the number of users or the amount per user, that sort of thing. But you're not likely to get big changes on licenses, for example. But the big overview there is decide if the tool that you're going to use is going to be good for your project. Obviously, it's easier to pick a different partner right at the beginning of your project rather than right at the end after you've used them for the last 3 years. Need to switch off. Just an extra note that I think is not on the PowerPoint, but important to consider is third parties aren't just little guys. They could be, the people you clean your office, or other smaller agreements. Rental cars, for example, those ones, it depends on the size of the partner that you're working with on how much you can negotiate. Obviously, the rental car companies won't let you negotiate the terms of your car. But if you're working with a sound studio to record some sounds for your game, there's no harm in asking, is the short answer for negotiating. You can always ask and they can say no, but they might say yes, and then maybe you have a better deal for your project. The final idea is with negotiating, you want to start early and start with what you want. It's harder to come and try to figure these things out uh, once you have something. A great example is if you're going to go develop these graphics with this person, or you're going to go develop, or you're going to go sell a product on the Steam store, it's really hard to then renegotiate things after you've already promised your potential customers or the people you're working with that's the way you're going to be doing things. If you've been telling everybody that you're going to be there, you're going to be releasing on Steam, and then you get to the point where Steam says, "Oh, well, you gotta comply with certain requirements to be on Steam." It's really hard. Then you've got to either back out and deal with your potential clients, or you've then just got to accept what Steam says, which likely you accept most of what Steam says given their market share. Um, but that helps you do things that you can adjust. Another great example is figuring out whether you're allowed to actually use the product materials that you're using. I remember actually a Kickstarter that I backed back in 2014 or 2015. Um, Sorry, I just looked it up. It's called Last Year. And for the first year or so, they had like a Jason Voorhees like slasher film character, and all of a sudden he disappeared. And you can tell they didn't go ill with the movie studio who has the rights to Jason Voorhees, because Dead by Daylight came out just a year or so later, is now much more popular, and has Jason Voorhees as a DLC character. I think it might be in the main game. So when you do these things up front, it's a lot easier to make sure you can do what you want. And the other reason that's helpful is it's easier to negotiate with someone who doesn't think you have anything. So if you're talking to whatever movie studio and say, "Hey, I want to make," another great example actually, you're talking to Games Workshop, who let anybody do something Warhammer, and you say, "Hey, we're just going to do this little game." Well, it's probably really easy to get the rights when they're just thinking you're going to make some dumb little game. But 4 years later, when you come out with Total War Warhammer, they're like, "Oh, well, maybe we should have got a better deal once once we see what the final product looks like." Um, I guess the final idea here is it's not entirely important what you decide these agreements look like right away. You don't need a big, thick, like stack of paper that's hundreds of pages long. The important thing to consider is what happens if we disagree, and you can do that in lots of ways. Think up, well, what if they want more money? Well, how do we resolve it? What if our game becomes yeah, actually a lot of problems resolve of how do we get more money? But maybe they don't like the direction you're taking their characters or taking their intellectual property, and they want to stop you. Well, okay, well maybe you want to consider some bounds on what you can do with these characters. Um, all of these things, you don't have to have the 100% like legal approved contract, though we obviously recommend it. That's just just here. But as long as you have the main ideas, even if that's just a like back of the napkin, both people just initialed on the bottom saying, "Yeah, this is what we want to do." And I think that's the most important idea behind negotiating and behind the contracts. So I think the last bit here is we've got financing and fundraising and IP, and I'll pass it over to Scott to take care of that.
I'll follow Eric's suggestions on the best way to approach the microphone. So yeah, I'm Scott Nicol, the N in Nicol Law, and I guess I'll be talking about some financing and fundraising as well as IP issues. So we'll hit the next slide here. The first one is one thing that sometimes comes up is people want to go and do some crowdsourcing. Want to throw your project on Indiegogo or Kickstarter, raise some money, and that'll be helpful in advancing your project. And so there's broadly two ways to do that. One is through pre-sales, and then what we see a little less commonly are equity crowdsourcing. People say you get to actually own a part of the project. And I guess the punchline on this is don't do the equity one. Pre-sales are relatively easier to account for, but also regulatory Regulatorily, quite a bit easier. Securities laws are very complex, and as soon as you're selling equity in a project, you have to comply with the securities laws. So the British Columbia Securities Commission has some guidance on how to do equity fundraising or crowdsourcing. But I'd recommend going and taking a look at it if you're interested. You can do equity crowdsourcing or crowdfunding. It's complicated, should be well planned and researched, and quite frankly, you might end up actually spending more on it, figuring out how to do it properly than you might achieve out of it. So I'd suggest simply accounting for those as pre-sales. And the next is, what's the value of having an organizational structure for fundraising? And this comes down to essentially that funding is a trade. When you go to a fundraiser of some kind, you tell somebody you want some money to advance your project, you're effectively going to be making a trade of some kind. And people with money will want to verify things like you have the right to your business assets. In this case, maybe right to intellectual property in a game. It's also going to be things like making sure that the business doesn't have a whole host of liabilities that it either might not be aware of or hasn't disclosed. So having good, what we call governance practices, can show both good organization and risk management and help people be confident that the right rights are there, the right ownership and intellectual property rights, as well as decent management over liabilities. Rarely do we actually, we don't normally see the expectation of perfection. When people go into funding transactions, they generally know that startups have started as scrappy startups, and they won't have, perfect sets of policies and great accounting controls and all that kind of stuff built in. But you do want to be starting from the gate with the right rights in place to be able to prove those to funders. And those are frankly simple things like having agreements with your contractors, having agreements with your employees, having a reasonable decision on whether somebody is a contractor or an employee, so that you don't have big tax liability potential, and things like having assignments of intellectual property built into your employment agreements and your contract agreements. So, and the other element, just kind of a punchline, complete and well-organized records demonstrate that you're managing the business effectively. Again, it doesn't have to be extensive, but what's critical to your business should be in order. All right, so next we want to talk about some intellectual property issues. One question it invariably occurs is how to integrate third-party IP in your project. And the reality is that essentially no project today is launched without using somebody else's intellectual property. If you go to make some source code, you're going to compile it with somebody's compiler. And that wasn't started from scratch. But even if you did, you're compiling that on a CPU with an instruction set that's being made by somebody else. So, and running it on a computer that's being made with a whole host of components with different rights negotiated by a wide range of different parties. So at some point, you are relying on third-party intellectual property at some level. What we look at in specific projects, and before you start integrating things that are particular to your project, you want to be careful because it's very difficult to unintegrate things. It's if you write your project in C and then want to immediately change pace and have it in Kotlin or something, it's not so easy as just kind of as it would have been from the get-go. You want to consider the risks of relying solely on one supplier. And this ties back to some of the agreements that you might negotiate with them. You also want to consider, even when you have agreements in place, what happens if a supplier goes belly up, maybe it gets acquired and it doesn't want to do business with certain customers for various reasons. There's all sorts of reasons that having a supplier and having their IP integrated into your project, if it's critical, you want to at least consider the issue before going ahead with it. There's also issues with using copyleft software or software that has kind of free licensing that requires any modifications or extensions to the code base to be shared with the community in an open format. We do tend to see clauses built into funding arrangements that can require, at the very least, disclosure of what software may be, quote unquote, tainted with copyleft obligations. But it goes back to kind of fundraisers or funders wanting to know that you own and have the ability to deal exclusively in the core intellectual property of your project. And that can be a problem if it's contaminated with copyleft software. So that's an example of something that's often easy to fend off at the pass. There might be a whole bunch of different libraries you can use and extend a little bit to meet your needs. But choosing one that's based on a free BSD license or one that's based on a GPL license could have a lot of different consequences down the road. And it might be better to take, a marginally technically inferior library that isn't going to cause you intellectual property issues down the road than one that will require disclosure of your code base. And again, the punchline here is that IP issues are often easily avoided at the start, and they're a lot harder to navigate once your project's being built around them. And next is a little tidbit on external advisors. So people like us. And hopefully this isn't too much of a marketing pitch. Of course, advisors can steer you in the right direction. We think that it's advisable to consider hiring advisors when you're going to be doing something that you perceive to be valuable or risky, or when you're going to be putting a lot of resources into something that you want to protect. Say like the litmus test for this and try to be objective in your perceptions of whether something's valuable, risky, or if you're putting a lot of resources into it. But if you put work into something and it was taken away from you, would you be upset? Or if you found out that your work was for nothing because of an external risk factor, that may be where it's useful to engage an advisor. People like lawyers, accountants, cybersecurity advisors. I know a lot of folks will probably, fit the bill of having good knowledge of the internet and ways to protect themselves, but that might not actually be their specialty. Don't always have to be expensive. Various models work to be able to get nudged in the right direction or assistance in completing something that's not within your skill set. For example, alternative fee models, fixed rate models, or even simply calling somebody up that you know and saying, hey, can we go for a beer? I've got this idea. This is what I'd like to do. Is this the right time to be engaging an advisor? Or what should I be knowing? What are the big things I should be concerned about? They might not be able to give you conclusive advice over a conversation or a coffee, but it might steer you in the right direction and help you make good use of what we know are limited resources. Because when you're running a startup, of course, you have to make good use of those resources. You only have so many ounces to spread, but an ounce of prevention is a pound of cure, as the old saying goes. So hopefully we haven't taken up too much of the stage time, but I'd like to invite any questions that we have from the audience. And Eric, Alex, and I can shuffle in and out and put masks on and off as necessary to field questions.
First off, just want to say thank you very much. There's a lot of very good information here that a lot of us, I think, can definitely take into account. I'll kick it off. I've got a question for you. When you gentlemen were talking about IP, do you have any thoughts on integrating third-party IPs that are within the public domain right now? Specifically, we've seen this a lot in board games using Lovecraftian themes, and from what I understand, all that sits in the public domain. But just any thoughts you might have on that?
I saw Eric raise his hand, so I think I'll take the cue as if I was back in school and just kind of give him a chance to talk.
Geez, everyone's taller than me. This isn't fair. I think the one thing that like flagged up immediately as you mentioned that, remember like Lovecraft and Lovecraftian aren't just written by Lovecraft. As people take something and they do something new or unique with it, they can actually generate their own IP protection. So you do want to be careful when you're looking at something, oh, that's clearly in the public domain, and you're not being inspired by someone who came later. That was my first twinge. But the second thing is, it goes back to the idea we have about how concerned are you about what you're making. If you're making like a fun little toy that like you think will just be like a free web toy or something, it's probably not a huge risk to try something that looks pretty clearly in like public domain. Like Brothers Grimm fairy tales would be difficult to argue that are absolutely protected and you need to be paying someone for. But if you're thinking of making like a game that you're hoping to compete with AAA titles, it's useful to look into it and figure out, okay, well, what are your sources, and to document those sources. Because that's something that can really help when you're looking at IP. If someone says, oh, well, you were inspired by my later version of this, you can say, oh, well, actually, I was reading, H.P. Lovecraft's original novella, and that's where I was looking at it, and that's where I got it from. So it's document where you get your ideas. It's not bad to have an idea journal or something like that just generally. But it's helpful if you ever get challenged on where those ideas came from or what you were inspired by. If you're going to use something in the public domain, and you're worried that this is going to be a big thing and get you a bunch of money, well, you're welcome to give us a shout. We do a free half-hour consult. But equally, you can like take a look and look into when things were published and look into those laws. And then the last bit is be careful about like blanket statements on IP. Sometimes like little niche parts can be protected. So
I would just add to that as well. Eric really is short. I would just add to that, like the concepts of public domain really vary jurisdiction to jurisdiction, and also frankly person to person. Just because the internet or Reddit or Slashdot or whoever thinks that something's in the public domain doesn't necessarily mean that it is. Something can be in the quote unquote public domain in one country but not in another, because intellectual property laws tend to be national and guided by some international agreements, but they will vary country to country, and the kind of rights, criteria, and objects around those laws will change between countries. So what triggers something to being in the public domain in one country might not be the case in another. And for example, the failure to have an appropriate copyright statement or notice at a particular year, resulting in something being, for copyright purposes, in what's understood to be the public domain, or without effective protection within one country so that you can use it, doesn't mean that the requirements of that copyright law exist in other countries where the creators could have their own independent rights that still have survived the transition to an unprotected work in the First Nation. So that sounds a bit complicated, but I think, as Eric said, the punchline here is, if you're going to be creating something that's important to you, it might be really good to consider that and perhaps get advice on it before you put a lot of effort in, or whether it's creating effort or marketing effort or what have you.
Awesome. Thank you.
So I'll throw out a question. I know this is something that's relatively hotly debated in the games industry. It kind of follows on a little bit from Mike's question about inspired by. Where do you draw the line between what is inspired by something, even in the real world, or something that exists, and what is directly copying something that already exists? In sort of general terms, what is it? What is inspired by, and what is a direct copy?
Yeah, good question. If I had the answer off the top of my head, I'd probably be a very rich person. It's going to be really circumstantial to what is being, what the original work looks like, and what the comparative work looks like, and it's very difficult to give concrete advice on that. One of the things that I would suggest is, if you consider what your intention is, and if your intention is to make something that's only as derivative as it be in kind of trying to narrowly guide this distinction down the line, that's going to attract hazard. And that might be something that you do if you consider that on the balance, your project is either so well funded that you can fight a big legal battle, or that you don't really care if it gets sidelined in the future. Otherwise, we suggest erring to the side of being a little bit conservative on that. Make differences more abstract. If a new work is kind of a bigger departure from what's already there and doesn't draw the mind immediately to the existing work, you're more likely to be in kind of a safe spot. But you're also, the benefits of that is that not only might you be kind of legally in the right, but you might avoid legal problems at all. And simply being legally right, but still having a big fight over whether or not you can use your intellectual property isn't a really favorable position to be in. So I think that that's a few of the things to consider. But what I'd also say is if you take people that are familiar with the existing work and were to show them your work, and it might be one of the approaches to take, if virtually any of them are saying, yeah, that's a copy, or man, I'm really seeing the similarities there, you might need to question whether that's the right way to be going when you're at a stage of being able to make your own work. Now, there are different things that are more or less subject to the ability to copy. So, for example, an unpatented invention, you can straight up copy that. It's fine. The actual implementation of that can engage concepts like copyright, or in certain cases, kind of trademark or trade name violations. Actual, text and literature, you can take the ideas, but any kind of direct copying is more or less prohibited. So, of course, unless you have permission from the rights holder. So, it can really depend on kind of what it is that you're copying as a concept.
Cool, thanks. Oh, it looks like there's a question in the chat from Stephen. He says, how effective / important are trademarks in regards to both company names and game titles?
Yeah, so a trademark is going to give you a greater ability to kind of claim rights over a name, or a logo, etc. But it is going to have its own limitations. So having a registration in the trademark database generally avoids one of the steps that's necessary to proving a trademark infringement, and practically makes it a lot easier to send a demand letter, tell somebody to bug off on using your trademark. Now, the limitation is both, again, going to the kind of national notion of intellectual property rights, where trademarks, to be effective from a registration basis, need to be registered in essentially every country you want to enforce them in. You don't necessarily need to have registered trademarks to be able to prevent uses, but again, it can prevent some harms. For example, and for example, in Canada, you can have common law protection of trade names and symbols and kind of other identifiers of your business by what's called a passing off action, where somebody's using something that looks like your product or business that is not you. And there's a few other kind of legal rights or causes of action, as we kind of call them, that can be relevant to protecting what you have as your name or your kind of project identity. But yeah, a registered trademark will certainly help lower the thresholds to enforcement, and particularly in countries where you have kind of a somewhat of a presence, where your project has somewhat of a presence, but you'll also have to determine from a practical perspective, which countries are actually worth registering in, because there can be a lot of cost to registering trademarks everywhere. And the reality is that most people with a name, a logo, or an icon will at most register it in a few countries.
Other thought. I'll just stay on my tiptoes from now on. I think that might be easier. The other thing I just wanted to add is the really common sense way to think about trademarks is to think of where the name came from. So a trademark was a mark on a product to show where it came from. So you'd think on like blacksmiths commonly would have their like specific logo. You can think of this from both sides. If your like studio or your developer or development team or whatever is valuable enough that you don't want people passing off their products as something like yours, then you might want to look into protecting your trademark. Equally, if you're putting something together that could be interpreted as making it look like it came from somewhere else, that's where you might be like edging on the line of trademark infringement. So. I'm just seeing if I can see the chat because we have our webcam up over the Discord.
Don't be shy. We know lawyers are scary, but Eric's not as scary as I am.
So I've got another one. Give some other people some time to think about questions. You were talking about restricted countries in which to sell in. I mean, I totally understand when you're, just selling your game on your website, you can determine what that would be. But what happens when you're on a global distribution channel like Steam or Epic? You don't really have any say of where those copies are going to. Will those platforms protect you from that, or how does that work?
Depend on your agreement. Steam probably should be fine. Unless you make nuclear reactor developer sim, selling that on Steam, and they somehow miss that you're selling to Iran. I guess the gist is these are very like specific exceptions, but they're areas that you should tread carefully around. There isn't a blanket ban on trading with Iran or China or Argentina. It's when you're trading in specific areas. So that's why I use Iran as the example, because everyone knows the nuclear trade prohibition with them. I believe there's a list of individuals as well that both the US puts out and Canada has one as well. And it's sort of, you can check names essentially. And then the final thing is if you're selling on like a full front, something you can do and a lot of web stores will do is say that the transaction is happening in their country. Now, it's not a perfect protection. If you're selling nuclear power plant sim to a bunch of Iranians, it'd be sort of difficult to tell the Canadian government, oh, but it was a sale in Canada. But that's one of the ways you can control what sort of jurisdiction you're making your sales in. Comments?
This comes down to me as a large part of, a risk management question, because even if you look at the biggest companies in the world, they screw these things up. And if your Apples and Googles sometimes end up offside compliance on obligations, I'm not saying on nuclear arms trading prohibitions from those companies, but if your large multinational companies end up finding themselves from time to time on the wrong side of a regulatory prohibition, whether it's a trade requirement, a tax requirement, or what have you, privacy requirements, the reality is that I would never advise non-compliance to people, but you just got to expect that there's a window of risk on what you're going to be doing, making a practical judgment call whether what you're doing has a great deal of risk or not. I think Eric's example is like, hey, if you're doing like a nuclear reactor simulator, you might have a higher degree of risk because that's a sensitive international issue for countries around the world feeling secure about what their neighbors are doing. And if it's really dialed into the physics of what's going on, you might be raising your concern. But I would suggest kind of a degree of kind of measure on what your appropriate measure of risk is. Is this, one person buying an off-the-shelf game off of a distribution site that probably addressed these issues? Like, I would have to look into it, but I would imagine Steam has considered the import-export issues around the world for generally ending up in compliance, or at least not ending up in trouble. And but it's, if you're fitting in the mold of what other people are doing, you're probably at relatively low risk. But if you're not, that's where you should be considering things. Now, I would actually add an example kind of to Eric's suggestion. There was a company a few years ago in Alberta sold a few O-rings. I think they were O-rings. And it amounted to a couple dollars. Like, we're talking literally $5 or $10 of O-rings. And they ended up being of the kind of O-rings made of a material that could be used in a high pressure sensitivity nuclear apparatus subject to export prohibitions. And this company that was like an O-ring supplier in the middle of Alberta landed something like $80,000 of penalties for $10 of O-rings leaving the country and ending up in Iran. So they are things that can happen. It's unlikely on your specific team that that's going to be, a huge issue. I'd probably be equally concerned about, ending up complying with GDPR, privacy laws in different countries, because the country will say, hey, well, you're getting revenue from a bunch of our citizens. Comply with our privacy laws if you're doing business in our country. So the reality is you're not going to have the resources to hire a crack legal team of experts to go track down every issue in every country that could arise. So you'll have to make some risk judgment calls on where you might be in greater hazard or where you're probably relatively safe.
Hulkins in the chat now has a question. A lot of indie games contain references to other indie games. How much would be needed to gain this permission for having a reference from another game? Would an email chain via the representative be enough, or do you need a full-on agreement in place?
All right, the other guys are telling me I should wing this one. Yeah, at the end of the day, what I do is I'd record the evidence that you have and just make sure that objectively you've actually, tied things off, that you can use a name or a reference. Generally, laws vary across different places in the world. So you could end up, just because you're developing something out of Alberta, doesn't mean that Alberta laws are going to apply to that sharing arrangement. They could go sue you off in German court or, somewhere, anywhere in the world, really, for misuse of things. Now, the reality is that having a reasonable agreement is first probably going to avoid the issue in the first place. Second, it's likely going to be, if not enforceable, persuasive to any scale of damages that somebody has, and it's really unlikely that somebody's going to be pursuing you if you've followed the terms of the agreement that you have with them. In a lot of those kinds of cases, yeah, it'd be great to have something in writing saying specifically what you can do, signed by people, whether they're digital signatures or ink signatures. But an email thread that shows a clear agreement that a name can be used under the common law. Like we have a common law system where contracts are only enforceable if they have consideration flowing both ways. So hopefully there's at least some argument that both sides are benefiting in some way from the transaction, and there probably is. You might gain some exposure and they might gain exposure, and the exposure going both ways is probably sufficient to be consideration. But having that recorded in an email is likely in a lot of cases to be acceptable in our view. And that's something that we often tell clients to do if there's kind of an agreement with somebody, if there's an understanding, and for whatever reason they can't get a more particularized agreement, it sure is better to have the email written down, even if it's your email saying, hey, further to our discussion on that chat last night, we're going to go ahead and put your name, reference to you in our live stream. Hey, that's, again, is it the gold standard? No. It's better than having nothing. And that's something that you can fall back on, say there were to be issues. Even in that example, if you'd be more likely to get an email back saying, hey, that's not what I remember, before you do that live stream and run into an issue.
My background's a little bit more around international trade law and regulations. So I mentioned that Scott touched on is if you guys are going to be dealing with those types of arrangements with companies in other jurisdictions, particularly Europe, there are a lot of agreements. There's the IPRED agreement, which is a European directive, as well as the TRIPS agreement and the Berne Convention, et cetera, from Switzerland that govern international IP, copyrights, trademarks, things like that are all included. That's not to say that you should have, or hire lawyers that are experts in that area, but just note that if you're going to be entering into those arrangements, have, like Scott mentioned, a document trail. It doesn't necessarily make a huge amount of difference whether you are making that agreement with somebody in Switzerland or somebody in Ontario, but just be aware that there are extra layers and treaties and agreements and conditions, particularly with European companies and privacy and data sharing of their users. So the data protection, the GDPR, which was instituted in Europe, tends to put and quash a lot of user sharing of data back and forth. So that's just something to consider. But in terms of just having those agreements in place, like Scott said, it doesn't necessarily matter as long as you have on paper and be able to, if somebody does question it in any jurisdiction, you can come back to them and say, yes, this person, we paid for it. Here's an agreement. Here's a chain of emails, things like that. So it always helps to have that. Anybody else before we wrap up the party?
Last call for legal advice from the associates at Nicol Law. Last call for questions. Questions going once. Not seeing any in the chat. Not seeing any in voice chat. Questions going twice. The forum for questions is now closed. Thank you so much, gentlemen. That was an awesome presentation.
Have a moderator.
Yeah, thanks everyone for sticking through this. Sometimes legal issues can be a long and arduous process. We're happy to do another one of these. Like, these are just the 10 sort of basic ones that we came up with. If there's anything here that like guys were interested in and want to go like deep dive, I know Scott really likes talking about IP law. I don't as much, but I'm sure I can say something. But equally, as I mentioned briefly before, we do a half-hour free consult. So if you do have like specific questions about your games, we'd be happy to chat with you guys and see if this is a good time to get us involved, or whether we think that this is a low risk thing and maybe you can handle it yourself. So
Yeah, if you have ideas on topics you'd like us to bring for CGDA, drop your CGDA directors and leads a note. Drop us an email, and we're always happy to put together some material. It's one of the ways. It's a community we like being involved with, and one of the ways that we kind of want to give back to the community. So if there's anything that we can do that's useful for you, let us know. If there's something that you're confused about, feel free to let us know. If there's
We'll send the PowerPoint and the notes.
yeah, we'll send out the PowerPoint and the notes. And yeah, if you ever have a question or if you see a gap in the legal world and you think, hey, there's a way that those legal nerds could help us solve that problem, give us a shout, because that might be something that you've got a great idea on that we're totally oblivious to, but there could be a solution there. So we always think more minds make better society. So thanks, everyone.
No problem. Thank you guys very much for taking the time and talking to us. And yeah, this was the first one, but I'm sure it won't be the last. So once again, thanks for coming out, chatting, and also great mask protocol. Dr. Dina Henshaw would be proud. A+, guys.
Yeah, Eric's taking a good care of keeping us in line.
Make good choices. Bye.